May But I'm praying for a little bit of connection with regard to item number 9. In this matter, my lord, my former senior, he was conducting the matter. The brief has come to me yesterday evening only. I'm praying for accommodation only for the day. Lordship will fix the matter in the next week.
Which item?
Item number 9. Any day in the next week.
19.
9.
9. Okay. Next Tuesday. What says the representative on the prayer made by Mr. B. Sharma, counsel for the petitioner? Matter since adjourned today, list on so and so.
Tuesday, man.
Tuesday.
Give
a date.
May it please, Your Lordship. That matter was earlier listed on 2nd May, my lord. That
We have to listing, give it to the court master, please.
May it please, Your Lord.
I get to mention item number 14, my lord.
Yes.
This matter has been listed after a long time, my lord. There's a huge brief, my lord. I could not prepare the brief, my lord, properly, my lord. Can it be taken up in the next week, my lord? Any date, my lord?
You have taken consent of the other side?
Except 11, my lord.
You have taken consent of the other side?
Yes, my lord. I have informed.
Okay. Consent of the other side, Mr. I.S. Sekia, counsel for the petitioner, place for adjournment. Here is allowed. List after a week.
My lord. God bless you.
May it please the Lordship. Lordship, item number 13 is a matter that pertains to regularization of grade 4 employees. This matter, Your Lordship, the petitioners have been working under an interim protection granted on 1st of February 2016. The matter has come up after 7 long years, but that is not the reason, Your Lordship. In fact, we need time to reconstruct the file. If Your Lordship can fix the matter, maybe as per Your Lordship's convenience next week. Any date, Your Lordship. We are working under interim protection. Okay.
What says the represented on the prayer made by Mr. M. Sharma,
Yeah.
counsel for the petitioner, list after a week. Entry matter past release stands extended till the next date of listing.
I'm grateful, Your Lordship.
May I please, Your Lordship? My lord, item number 19, my lord. Your Lordship is our, my lord, sir, HRS, my lord. Can it be taken on next Thursday, my lord? Otherwise, there is an urgency, my lord. Dismissal from service due to negligence on.
List after a week is paid for by Mr. AHMR Chaudhary, counsel for the petitioner.
My lord, can it be fixed on next Thursday, my lord?
It will come. It will come. Yeah, old matters. This is a new matter.
New matter, but dismissal from service on alleged negligence on duty, my lord. And petitioner has minor children, my lord. Otherwise, my lord, everything is ready, my lord.
Is it?
Fine.
Let's do it with 13th June.
Obliged. Next, please, Lordship. Lordship, I have to mention item number 4 and 5, my lord. I'm paying this matter maybe password for a day, my lord.
List after a week is paid for by land counsel for the petitioner.
Lordship, I like to mention for emergency the listing to that listing.
Daily list item 1 with 2.
Please, Your Lordship. In this matter, Lordship, Arjun Counsel, Mr. H.K. Das is appeared, Lordship. He is on left in court number 1, Lordship. Lordship may take it up after some time, Lordship.
Okay.
Deeply obliged, Lordship.
Part third item 20.
That matter, my lord, where Your Lordship has concluded the hearing, my lord, from my side.
He's on lax in code 26. So.
What is time?
Timing.
Timing.
You may not be here. You may not be here.
Yes. I'll be there because.
In item number 1 and 2, I am for the respondent. But my learned friend is having some problem, he says, in time being. What I can do, my lord, I can make my part. In any case, he has a right of reply. He can say in one go.
Let him say, otherwise you may not be, you will not be, what you call, arguing on what he is trying to say.
Okay.
Lordship, I beg to mention item number 11.
Answer is over.
Item 3.
May I please, Lordship? Kindly pass over the matter for the time being, Lordship.
Timing. Okay.
It is the lawsuit. In this case, one of the petitioner of the lawsuit has been imposed with a compulsory retirement. Has been imposed a punishment of compulsory retirement.
Yes.
In this case, the petitioner of the lawsuit has been imposed with a punishment of compulsory retirement. First one, the disciplinary proceeding, my lord.
Yes.
The allegation is that, my lord, the petitioner is an employee of NTRO, my lord. And he, along with another person, my lord, invited to, my lord, lady guest to their quarter, my lord. And without making entry in the entry gate, those ladies were brought to the quarter. So, my lord, disciplinary proceeding was initiated against them. And most of them were, my lord, punished with compulsory retirement. This will find the memorandum of charge, this will find at page 18, my lord.
Where is your second showcase reply?
Second suppose reply, my lord, the petitioner did not keep it in, my lord, copy of this, my lord, he did not keep it in. And, my lord, that is why, my lord, we could not annex it, but it will be there in the record of the case, my lord. Record
You have the record?
Yes.
Any reply file, second
We have
showcase
filed a
reply?
reply, my lord. If record required, then I'll produce, my lord. We have filed our affidavit in opposition, my lord.
No, but if you are hearing it, you will have to produce the records.
Yes, my lord. Some date may be fixed, I'll produce the record.
Both sides are represented. You have the stand taken by the petitioner. The perusal of the records of the disciplinary inquiry against the petitioner is required to be perused. Next one. You say Gayan Leonard. CC shall produce the relevant records. How much time?
Malat, immediately after vacation.
Only before vacation, madam, this compulsory retired, madam.
We'll need some time to get the records. If there's no order, they will not produce the records unless we ask them to produce. So, never done. This one, 18/7/2024. In your affidavit, what do you say about the show cause reply, second show cause reply? What is your stand?
And so called reply, madam. Yeah. Malak, in page 62, Malak. Page 52, para 8. The content of the para are wrong and hence no so cause notice dated 25/6/20 was issued to the, however, had later dated 25/6/20. From 62, page number 62. Running page 62, para number 8.
Yes, please read.
My lord, the content of the para are wrong, hence there are no so cause notice dated 25/6 was issued to the petitioner. However, while later dated 25/6, the inquiry report dated 11/6/20 was forwarded to the petitioner for his written representation, if any pursuance of the Rule 15(2) of the CCS Rule 1965, my lord. That is, my lord, not the second so cause notice, that is reply to the annexer 6. Page 82, annexer 6, man.
Page.
Page 82, annexer 6. That is later dated 25/6/2022. 20. This is not the second second, that is, my lord, two charges officials, so and so, are hereby directed to submit their respective written representation, if any, on the inquiry report within 15 days.
This is not a case of total denial, my lord. The only thing, my lord, the punishment is, my lord, too harsh, my lord. So far the gravity of the offense, my lord.
With that, we don't think that the record will be necessary.
Yes.
Because, my lord, it is admitted position that the petitioner received those two ladies, my lord, from the entry gate. My lord, the other person, Ravindra Kumar, my lord, over from his telephone, my lord, he called those two ladies, my lord, to the quarter, and those two ladies enter into the campus, my lord, quarter without making entry in the entry gate. That is the only offense, my lord. And for that offense, my lord, they have been, my lord, compulsorily repaired. So, my lord, the punishment and the offense is not proportionate, my lord. As, my lord, nothing was complained from those two ladies. Nothing was found from those two ladies, my lord. They were also searched, they were also arrested, my lord. For its raised to, security of the campus is concerned, my lord. Nothing of that sort was found from those two ladies. It's admitted question that, my lord, the two ladies came. It's not that they forcefully brought those two ladies, my lord. They voluntarily came, and, my lord, they were found having alcohol inside that, my lord, quarter.
Yes.
My lord, will find us memorandum of charge at page 18, my lord. The article of charge will find at page 20, my lord.
20.
20, article of charge.
Yes.
That the said Satish Kumar Mishra JFA, while functioning as such at NTRO base unit Numaligarh on 36/2019, and Sri Ravindra Kumar, MT assistant, be invited and unauthorizedly brought inside NTRO campus two women from public there at around 1500 hours without making entries in the out register at the gate number 2, despite security personnel at the gate asking them to do so. Sri Satish Kumar Mishra and Sri Ravindra Kumar then proceeded to entertain the aforementioned late woman in the vacant quarter of another official. These actions of Sri Ravindra Kumar and Sri Satish Kumar Mishra amount to severe indiscipline and serious breach of security of protected premises of an intelligence organization in violation of para 2B of NTRO security instructions that it so and so, chapter 3.1 of the NTRO Department of Security Instructions, number of 2005. They also amount to serious breach of personal and official decorum and conduct in violation of provisions Rule 3.1, Roman 3 of and Rule 3.1, Roman 13 of the CCS Conduct Rules 1964. Hereafter, the petitioner submitted his representation that was not held to be good, my lord, and accordingly, my lord, inquiry proceeding was initiated. The inquiry report was still find at page 26, my lord.
Yes.
Page 26 is the, my lord, forwarding letter. The inquiry report starts from page 27, my lord. The findings was still find at page 40. Findings, in view of the above findings, statement and analysis of the evidence, including circumstantial one, it is beyond any reasonable doubt that both the search officers invited and unauthorizedly brought inside NTRO campus two women from public without making entries in the in and out register at the gate, and thereafter proceeded to entertain these women in the vacant quarter of another official in absence without even seeking his permission. This is the findings. It is not denied, my lord. It is admitted that those two ladies were brought. They came into the campus, my lord. They were known to the other accused person, my lord, the Ravinder Kumar. He over telephone invited them, my lord. They came. So this is the only finding, my lord. From them, my lord, no allegation of such, my lord, any moral turpitude or anything was given by, but ladies, my lord, never complained. And nothing was found from the ladies also, my lord. So this, on the basis of these findings, we should find the impugn order at page 44, my lord. Last paragraph, my lord, paragraph 11, page 47.
Yes.
Paragraph 11, page 47, my lord. In view of the above, there are good and sufficient reasons to conclude that the search officer Sri Satish Kumar Mishra, JFA, has rendered himself unfit for continuation in government service. Satish Chandra Jha, Chairman of NTRO, accordingly, in exercise of power vested under Rule 15 of CCA Rules and 65, order imposition of penalty of compulsory retirement on him with immediate effect.
This establishment of National Technical Research Organization
Fine.
is a defense establishment.
Yes, sir. an intelligence agency, my lord, directly related to raw, my lord.
Hmm?
Under raw, my lord, they works. Intelligence agency. No? No, my
Yes.
lord. Next, my lord, hereafter, my lord, the petitioner filed an appeal before the competent authority, my lord. The appeal was also dismissed, rejected, my lord, page 49. Section 9, my lord. Well, Lord, kindly turn to page 51, my lord, of the appellate order, my lord. Paragraph 9.
Yes.
Paragraph 9. My lord. Whereas now Sri Satish Kumar Mishra, the appellant, had his appeal number, appeal dated 1/10/2020, had pleaded that he got involved in the said incident unintentionally and that he has 3 children, 2 daughters, aged about 15 and 12 years, and a son. That his financial condition is very poor and his job is his only support, and that he begged for pardon with assurance not to repeat such mistake in future.
Yes.
It is not that my lord, he has denied the allegation. He has admitted that 2 ladies were brought to the quarter, my lord, but my lord, he undertook not to repeat such incident in future, and he begged apology from the authority also. My lord, subsequently, my lord, paragraph 11, page 52. The- Therefore, the appellate authority, having considered the appeal of the said Satish Kumar Mishra and the report of inquiry authority, agreed with the decision of the disciplinary authority. Hence, the appeal dated so and so of said Satish Kumar Mishra is hereby rejected.
Yes.
Malad, this is the only solitary charge on during his Malad, service career. Before this incident, Malad, there was no allegation against the petitioner whatsoever, Malad. This is the only incident during his entire service career. So, Malad, as being the single incident, Malad, he could have been imposed with a lesser punishment also, Malad, instead of giving him, punishing him, Malad, with compulsory retirement. On the point of, my lord, disproportionate punishment, my lord, I am relying on some decision of this honorable court as well as honorable apex court, my lord.
Yes.
My lord, 2006 supplementary GLT 316,
Yes.
Mackenzie, my lord. Merciless body. I've given the copy. Here, my lord,
Yes.
must will find the text of the case, paragraph 9, my lord. Paragraph 9, my lord.
Yes.
But the appellant in reply to the charge sheet had admitted that on 7/5/95 he traveled by the night super bus from Shillong to Tura with his service revolver loaded with live ammunitions and dispersed money, even though he was instructed to come by official vehicle. An explanation has been given for not using the allotted vehicle to the effect that the vehicle was detained at Shillong by the department and no other departmental vehicle was made available to him to come back from Shillong. Regarding allowing the constable Lightfoot Sangma to go to his residence without permission from the competent authority, the appellant denied the same. The explanation has also been given about the loss of arm and ammunition and money by contending that he was administered drug by a co-passenger by insisting to take some sweets. It is evident from the record that the appellant on arriving Tura on 8/5/95 immediately informed the commandant about the said incident and explained the circumstance under which he lost his service revolver with ammunition and the money, whereupon an FIR was registered. The version of the appellant that he was administered drug also finds support from the examination of blood conducted by the forensic science laboratory, who found the presence of chlorpromazine, a tranquilizer drug which can cause unconsciousness. The inquiry officer in his report has reported that the finding that the appellant was returning to the battalion headquarters from Shillong in the night bus alone on the night of 7/5/95 and he lost his service revolver with ammunition and money. The version of the appellant has not been disbelieved by the inquiry officer. However, the inquiry officer has rightly found the appellant guilty of the charges leveled against him. Now let's find paragraph 19, 20 and 21, madam. Page 4, madam. Penultimate paragraph.
Yes.
As discussed above, the appellant at no point of time denied about his travel by night bus on the night of 7/5/95 and also about the loss of the service revolver with ammunition and remaining undisbursed amount. The inquiry officer also did not recover any finding disbelieving the stand of the appellant regarding circumstances under which he had to travel by a Meghalaya State Road Transport Corporation night bus and also taking a suite by him at the insistence of a co-passenger, which made him unconscious. The said version of the appellant has in fact been supported by the report of forensic science laboratory which finds its presence in chlorpromazine, a tranquilizer drug which can cause unconsciousness in the blood of the appellant. The appellant in fact immediately on arriving his headquarters at Tura faithfully informed the commandant, that is his disciplinary authority, about the occurrence without hiding anything. From those factors, it is therefore evident that the appellant was a victim of the circumstances. He has also not set up false case. It is also on record that the appellant has served the department since 1967, that is for about almost about 28 years prior to join of the disciplinary proceeding without any blemish. The act attributed to the appellant therefore being not intentional, and in view of the aforesaid discussion as well as the law laid down by the apex court, we are of the considered view that the same case in hand is an exceptional way on where the punishment awarded by the disciplinary authority of removal from service is not proportionate to the proof misconduct. However, the appellant is in no stretch of imagination can be held to be not guilty, as his action reflects his letharginess and also his irresponsibility, which can cause loss of service with ammunition and also undisbursed money for which he has to be adequately punished. In view of the aforesaid discussion, while upholding the appellant is guilty of misconduct, we set aside the order of removal from service and remit the matter to the appellate authority, namely the Inspector General of Police, to consider and inflict appropriate punishment short of removal from service, commensurate with the gravity of the proven misconduct. The appellate authority is accordingly directed to pass appropriate order in terms of the provision contained and so on, so and so. So, Malad, here also, Malad, this is not a case of denial. Malad. He has admitted that he brought those two ladies, he along with the other person, Malad. And Malad, this is the being a solitary incident, Malad, and now no harm was done by the two ladies. So, he could have been imposed with a lesser punishment, Malad. In 1998, 3 SCC by Lord 192, color came limited. Paragraph 3 is the facts of the case. I'm sorry, my lord, the size of the letters are small, my lord. I'm also having some difficulty in reading.
Yes.
Well, paragraph 3 is the facts of the case, my lord. Here, my lord, some persons were, my lord, factory works, they were doing sleeping while the machine was working. My lord. Now, this is the fact of the case. Now, ratio was been fine. Paragraph 13 and 14, my lord.
Yes.
May I read the text of ratio. I'll directly come to paragraph 13, my lord.
Yes.
So for this point, is concerned, it has to be held that when the punishment of dismissal was shockingly disproportionate to the charges held proof against them, a statement with continuity of service was the least that could have been ordered in their favor. There is no question of appellate losing confidence in them. In this connection, Lanet Senior Counsel of the appellant tried to submit that apart from going to sleep in the early hours of the morning, when the night shift was coming to a close, the machine was kept working and would have created a hazard for the working of the plant, and possibility of explosion was likely to arise. So far as this contention is concerned, it must be stated that this was not the case of the management while framing the charge sheets against the workmen. Not only that there is not a whisper about the said eventuality and possibility of the evidence led by the management before the labor court, but that apart no such contention, even though mentioned in the written objection before the labor court, was ever pressed in service for consideration before the labor court at the stage of argument, nor any decision was invited on this aspect. No such contention was also canvassed by the appellant in revision before the industrial court or before the high court. This contention therefore must be treated to be clearly an afterthought and appears to have been rightly given up in subsequent stage of the trial by the management itself. All that was alleged by its witness before the court was that because of respondents going to sleep and allowing the machine to work without pouring raw material therein, the production went down to some extent. That has nothing to do with the working of the unattended machine becoming a hazard or inviting possibility of any explosion. Under these circumstances, and especially looking at the past service record of the respondents, it could not be said that the management would lose confidence in this workman. The work which they were doing was not of any confidential nature, which an operator has to carry out in the plant. It was a manual work which could be entrusted to anyone. Subsequently, the submission of Lanet Senior Counsel of the appellant that in lieu of the reinstatement, compensation may be awarded to the responding workman with continuity of service. However, because of misconduct committed by them of sleeping while on duty in the night shift, the labor court has imposed the penalty of depriving the workmen, respondent number 3 and 4 respectively, of 60% or 50% of back wages. After the award, they have been granted 100% back wages till reinstatement. But in our view, as respondent number 3 and 4 went to sleep while on duty, that too not alone, but in company of the entire staff of 10 Mazdus, they deserve to be further punished by being deprived of at least some part of back wages even after the award of the labor court till actual reinstatement. Interest of justice would be served in our view if respondent number 3 is directed to be paid only 40% of back wages even after the award of the labor court till actual reinstatement pursuant to our present order. Similarly, respondent number 4 will be entitled to only 50% back wages even after the date of labor court's award till actual reinstatement as per the present order. In addition thereto, the appellate management will be entitled to give written warning to both these respondents when they are reinstated in service not to repeat such misconduct in future. The imposition of this type of additional penalty, in our view, would be sufficient in the facts and circumstances of the case and will operate as suitable corrective for the time when they went to sleep.
It's okay, we have read it.
So, my lord, this is my contention is that, my lord, the punishment imposed upon the petitioner is not proportionate to the gravity of the offense. So he could have been punished with a lesser punishment, my lord, as no harm was done by those two ladies inside the campus. And no complaint was lost by them also. This is my humble submission to the question.
Yes.
May please your lordship. From page number 54 to 59, my lord, we have stated that whole the process of the inquiry, we have given given him to file the written statement. Inquiry officer was appointed, presenting officer was appointed, my lord. May I read from page number 54, my lord? My lord, my submission is that, my lord, procedure has been followed, my lord, during the disciplinary proceeding, my lord. There is no lapse in the disciplinary proceeding, my lord. Neither the national justice has been violated in the disciplinary proceeding. And my lord, kindly NPRO, my lord, considering the organization, NPRO is a, my lord, this is an organization of in a premium intelligence organization of the country working under the direct commandant of national security advice. We have stated in page 65 of our affidavit in opposition. They work for the national security of our country, my lord. And this is a very premium
You are
intelligence.
reading from where?
Page number 65.
65.
65. Running page 65, my lord.
Which para?
Para 18 to 23, my lord. That the disciplinary, may I read, my lord?
Yes.
My lord, next, my lord, kindly come to page number 79, my lord. Statement of that petitioner, my lord, 78. Annexure 5. Page number 78 is the incident, my lord. And page number 79, my lord, first question was, were these omens known to you? No. Why do you took both the women inside the campus, sir? Sri Ravindra Kumar requested me to take them inside the campus as both women are his guests. Where was Sri Ravindra Kumar at that time? He was also available at gate number 2, but busy on the mobile phone. Once he was available in the, why you don't told him to take the guest inside the campus as he was busy in phone on considering the guest of Sri Ravindra Kumar. I took both of the women inside the campus. Sri Ravindra Kumar requested you to take them to your quarter. Why that you have, why you have taken them to the other quarter? My room was not in the good condition. That's why I took them to the quarter number so and so. Did you offer the alcohol where woman visitor? No. Did Ravindra Kumar offer the alcohol beer to the woman? Yes. How many years of service you have put up into the NTR? Almost 14 years of service. Are you aware about the existing security instruction for the visitor entry exits inside the campus? Yes, visitors are permitted based on the gate pass issue. That is the admitted, my lord. And can you take the visitor inside the residential official complex without the gate pass? No, but in residential campus, visitors are permitted by making entry into the visitor registered place at gate number 2. Why you you and Mr. Ravindra Kumar did not make entry in the register of the visitor at gate number 2? This was my mistake and I admit this. Did you inform HO or ASO about the visitor of the woman guest? No, I did not inform them and I admit my mistake. Here, my lord, he brought these two ladies to the another quarter who was on leave at that time, my lord. That is the serious, my lord, misconduct, my lord. And in case number my lord, in inquiry report, my lord, that is specifically proved, my lord, that is in page number. Kindly see, my lord, page number 29 of the writ petition. Sirs, my lord, second paragraph. Sri S.K. Mr. admitted that he took the two women to the quarter of another official without making entries in the in and out register, but he stated that this was done by him on the request of Sri Ravindra Kumar and he did not know the woman. In spite of knowing, they didn't have the knowledge about the women, they brought this lady to inside the NTRO, my lord, that is the premium organization. Sri Ravindra Kumar denied, and Ravindra Kumar, my lord, that is another person, denied having known the woman or having asked Sri S.K. Mishra, that is the present petitioner, to take them inside. But he admitted that he went to the quarter where Sri S.K. Mishra took the woman and he did this after being invited by the Sri S.K. Mishra to come to the said quarter. My lord, next, my lord, page number 31. Brief statement of the case in respect of the charge inquired into. During the inquiry, statement of the witnesses and the search officers were recorded. The search officers were provided with all the opportunity to defend themselves, including the cross-examination. However, they denied to either cross-examine or to appear their own witnesses. Both the search officer admitted the fact that they were present with the two women in the quarter of another colleague, my lord, and were having the snacks with them. And Sri S.K. Mishra stated that he escorted the women inside the premises and took them to the quarter of the colleague who was not present at that station. Sri Mishra, who also admitted that he did not make any entries in the in and out register kept at the gate. While admitting it was a mistake, he stated that the guard on the duty also did not insist on making the entries, as he could not have forcibly escorted the women if the guard persisted and prohibited their entry. However, Sri Mishra reiterated that he received the women at the gate and took them inside the premises at the request of Sri Ravindra Kumar. Sri Ravindra Kumar, on the other hand, has denied of making any request of to Sri S.K. Mishra. On the contrary, stated that it was Sri S.K. Mishra who called the ladies using the mobile phone of Sri Ravindra Kumar, and Sri Mishra himself took the ladies to the quarter of Sri Vinod Kumar.
Yes.
Then, my lord, after taking the woman inside the quarter, Sri Mishra invited Sri Ravindra Kumar to join him with his guest, and therefore the Ravindra Kumar went to the said quarter. All the witnesses have mentioned that they have seen the SARS officer in the company of the women who were later escorted out of the premises. My lord, here that has been proved that he brought these two lady, not on the request of Mr. That another, that is Rabindra Kumar, my lord. That is his own statement, Rabindra Kumar's statement, my lord. And
Yes.
my lord, here my submission is that, my lord, here that SARS has been proved, my lord, and procedure has been followed, my lord. And in this regard, I would like to submit one and in 2019-40, that is the power of judicial review under 226, my lord, in paragraph 40, 41, and 42, my lord. That is in second page, my lord, it was held. Here, my lord, everything is based on the evidence, my lord. So, my lord, my humble submission is that 226, my lord, that cannot be interfered, my lord. Paragraph 41 is the relevant And this is, my lord, regarding the proportionate punishment, my lord, misconduct for misconduct. My lord, page number, paragraph 22, last para, my lord. In paragraph 22, my lord, that in that case also, my lord, misconduct has been proved and that the punishment is the compulsory retirement. My submission is that compulsory is not the disproportionate, my lord. And considering the weightage of that institution, my lord, that is not not that disproportionate, my lord, as per that R.L. Parekh versus High Court of Gujarat, my lord. That is my submission, my lord.
Past origin changes.
Yes.
This is again past origin changes.
That was all.
Past origin changes.
My lord. My only previous prayer is, my lord, the gravity of offense and the punishment are not proportionate, my lord. Lordship may consider that aspect, my lord, the petitioner has family and he has some liabilities also, my lord. So, my lord, considering the entire fact, Lordship may kindly. Oblige, my lord.
Must have. Very enough.
Time being item 1 with 2.
My lord, before I resume my submission, Lordship will remember on the last occasion, my lord, I almost completed my submission and I was about to place the judgments before your lordships. Now, in the meantime, day before yesterday, my lord, the private respondents, they have filed an affidavit, my lord, without seeking leave of this court, because substantially I have completed my submissions, my lord. Now, perhaps lordship has to take a call whether to accept that or reject that affidavit, my lord. This affidavit is which item? Item 2, my lord. Because record or I said, record.
My lord, flag D is the affidavit, my lord. Flag D, my lord. D, my lord. WPC, my lord, 4255. In the office note, my lord, it was wrongly put as a flag A, my lord.
Who is appearing for respondents for 6 to 14?
My lord, I am appearing, my lord, on behalf of my lord, Garnish Senior Counsel, Mr. K. N. Chaudhary, my lord.
Sorry, why should we accept this affidavit of respondent 6 to 14 on board? 6 to 14,
Yes.
they filed an affidavit in opposition. Why should we accept it on board?
My lord,
Because-
actually,
Because there are two orders. First, there's an order which says that an attempt would be made to dispose of the matter at the admission stage.
actually, essentially, my lord, we have raised a question of law. That is that writ petition is not maintainable. That is
No,
basic.
But if pleading comes after, in a parted matter,
It's a matter.
Mm. we'll have to recuse ourselves.
Huh?
Uh,
Oh, then we should have taken leave.
no, then I'll
I'm sorry.
recuse. Then I'll have to recuse because they can't remain parted.
Or lordship, we are not pressing the affidavit. We will not press the affidavit. I'm sorry, actually, I was not under the impression that it is part. I'm sorry.
No, it's parted. Yes, sir.
Oh, I'm sorry. In that case, we should have taken leave. Yes, yes. No, no, question of law here.
But if you have a substantial issue, then we'll let it come
Well,
some other day.
actually, we are not, actually, there's some miscommunication. We thought it is not part. If it is part, then we are duty bound to seek leave from your lordships. And since we have essentially raised a question of law, even without that affidavit also, we can advance that argument. Because state's affidavit is already on record. It is basically the state's action, which is being challenged.
Yes.
I'd just like to refresh your lordships with the facts, my lord. The petitioner, she got promotion to senior lecturer on 35/2023, page 88, annexure P15. Now, the issue herein is that with regard to, my lord, whether the qualifications prescribed by the NCT guideline will have to be followed by the state government or not. Now, Service Rules 2010, annexure P17, I'll just take your lordships once more.
No, not required because
Lordship, fine.
it is your case that except for serial number 5, all are underqualified.
Yes,
That
sir.
is your basic argument.
Yes,
And you say that the DPC recommended unqualified persons.
unqualified persons. That is my precise case, madam. Now, the NCT regulations, that page 113, relevant portion is at page 116. It provides PhD and MA with 55% mark as qualification for the post of principal, my lord. Now-
And your argument is that this diet carries out 2 programs.
B.Ed and DLED.
And
DLED.
therefore, there's a requirement of that,
Yes,
what you call it, PhD.
PhD and MA with 55% marks. And it is their case also in the affidavit in opposition that this PhD and MA with 55% mark is only for B.Ed course and diet, it's a contradictory stand by them in their affidavit. Now, after this regulations of 2014 and thereafter a amended regulation of 2017, page 127, I'd like to read before you, one paragraph I'd like to read before your lordships once more, by which, my lords, the government of Assam had issued a notification by modifying the qualification prescribed for the post of lecturer, which is the feeder post. So for the post of lecturer, they have incorporated the change, but for the post of principal, for which the regulation came in the year 2014, they just set over the matter. Now it says, my lord, one paragraph I'll read, whereas education being the subject of non-concurrent list and NCT being the statutory body of Government of India for teachers' education, whereas education being the subject of concurrent list, NCT being the statutory body of Government of India for teachers' education, has prescribed norms for teacher education courses as well as qualification of teacher educators as per NCT norms and standards. Most of the fund in this regard is being borne by the Government of India. This is important, my lord. For conducting teachers education programs sustaining NCT recognition. Keeping above in view, the Government of Assam pleased to revise the existing minimum qualification for all categories of posts of District Institute of Education Training, Government BT College, College of Teacher Education, and State Council of Education Research and Training as per the norm standards prescribed by NCTA as follows. So pre-service PhD teacher lecturer, it has been provided PhD in serial number 1. So the entire funding is by the central government. You are following the NCTA guidelines for lecturer in the feeder post, but so far as post of principal is concerned, you are not implementing it. And your stand is that this is only for B.Ed. If that be so, even assuming that is correct, diets imparting B.Ed and DLA, has to follow this qualification for the post of principal. Now, they once held one DPC, page 141, my lord, I referred on the last occasion, wherein they said for as a one-time measure, we are relaxing this and we are appointing person without senior lecturer, without the qualification of PhD and MAd with 55% marks. Now, in their affidavit, they are just disputing this minutes of the DPC, my lord, in their affidavit. Before the writ petition was filed, my lord, one senior lecturer who was a PhD, she was given promotion in pursuance to the DPC recommendation, impugned DPC recommendation, that is 151. Thereafter, they did not give. And this honorable court was pleased to pass an interim order that not to give promotion to the underqualified teachers. And after that, 2 persons who were about to retire or on the verge of retirement, they approached this honorable court seeking leave that we are retiring. So kindly allow us promotion. Then with certain riders, this honorable court, my lord, directed the respondents to give them promotion subject to outcome. And there are 2 more riders in the order passed by this honorable court.
Where is the statement in the affidavit in opposition denying that DPC?
Yes, my lord. Para 10. Para 10 of the affidavit filed by respondent number 2. Now, SCRT also filed one affidavit. Para 11 of the affidavit will be relevant. My lord. The respondent number 3.
What do you want to show from para 10?
Para 10, they said the answering deponent states that the DPC meeting held on 12 to 2021 instead of 4 to 2021. In my statement, I said that DPC meeting was held on 4 to 2021, wherein they gave one-time relaxation. And that's
You are referring to 141,
page
page
1.
141.
Milord, 1 second. Yes, Milord.
He is relying to page 141, a minus of 42. In our affidavit at para 10, my lord, we have said that there was no minus of 42. It is of
No.
12.
No, something is wrong. 141 is 4 to 2020.
No, Milord. It's Milord. That was a typographical error. It is 4 to 2021, Milord. In the top, Milord, it was a typographical error on my part. It should be 4 to 2021.
Okay.
Page 142, I have written, they have seen 4 to 20.
In my statement also, Milord, I have said.
Statement is also 4.
So they say, Milord, there was no DPC held on 4 to 2021. DPC was held on 12 to 2021. And pursuant to that 12 to 2021 DPC, promotion was given by 25 to 2021. So basically, they tried to say that there was no decision of this one-time relaxation by the authorities.
Executing people is a medical decision can be snatched. And these are only.
Yes.
I was just referring to the affidavit by SCERT, that is respondent number 3, para 11. Page 204, perhaps. That as regards the statement made in paragraph number 20 and 21 of the writ petition, the answering deponent begs to state the NCT prescribes the norms and standard for different teachers' educational institutions. The prescribed qualification stated in the petition is applicable against the B.Ed course only. The recruitment to the post of lecturer and promotion to the post of principal and senior lecturer are made in accordance with the District Institute of Education and Training Service Rule 2010. In the said service rule, requisite qualification and experience for direct recruitment to the post of lecturer has been prescribed, where requirement of PhD for the post is not mentioned. Now, para 12, as regards statement made in paragraph 22 of the writ petition, the answering deponent begs to state that the respondent number 3, that the director SCERT issued letter to the DIET CTEs for fulfilling the NCT requirement for introduction, continuation of B.Ed and D.Ed programs. So that means the SCERT issued letters to all the diets and CTEs that you have to follow the NCT requirements for introduction and continuation of the B.Ed program. So in sum and substance, if you want to introduce and continue B.Ed in diet, you are bound to follow the NCT regulations. Yes. On the last occasion, my lord, your lordships also wanted me to address on the order of this honorable court passed in another writ petition in WPC 2293, which judgment was relied on by the respondents in the DPC, saying that that there was an order in WPC 2293 2019 that they are to follow, they are to select the principal by following the rules of 2010. They cannot deviate and they cannot follow the regulations. Some sort of that impression was given in the DPC minutes. Now, this judgment was completely on different pretext, my lord. This was a judgment wherein two persons approached this honorable court with regard to their dispute concerning seniority. One was saying that he was senior, so he is to be made in charge principal of the diet. My lord will kindly come to page 144. I'll just read some paragraphs of this judgment, my lord. Lordship will find that the entire facts are totally different vis-a-vis the issue involved herein, my lord. Para 144, my lord. Sorry, my lord, page 144.
Yes.
Third paragraph, my lord. Both the petitioners and respondents took over charge as senior lecturer of Diet Gwalpara Dudnoi on 1/1/2015 and gradation list of lecturers of Diet under Director of SCERT Assam published on 26/6/2014. The seniority position of the petitioner was at serial number 33, whereas that of respondent number 3 was at serial number 50. The petitioner joined as lecturer of Diet at Gwalpara on so-and-so, whereas respondent number 3 joined as lecturer Diet Dibrugarh on so-and-so. 2 months later than the petitioner. The erstwhile in-charge principal of Diet Gwalpara Dudnoi retired from service on so-and-so on attaining the age of superannuation. The respondents in the elementary education department and the directorate of SCERT Assam allowed respondent number 2 to hold the charge of principal in charge of the said Diet Gwalpara, Dudhnoi, disregarding the seniority claim of the petitioner, hence the writ petition. Now, my lord will kindly come to page 147.
Yes.
Third paragraph, my lord. The records placed before the court also reflects that on the basis of the letter dated 9/3/2019, the local MLA of Dudhnoi constituency favoring the respondent number 3 for in charge principalship of Diet Gwalpara Dudhnoi, and as per the verbal instruction of the departmental minister over telephone, the respondents in the elementary education department as well as the directorate of SCERT Assam on 30/3/2019 decided to hand over the charge of the principal in charge of Diet Gwalpara Dudhnoi to the respondent number 3. Accordingly, the director SCERT Assam by his letter dated so-and-so directed the principal in charge of Diet Gwalpara Dudhnoi to hand over his said charge to the respondent number 3, observing that the same is purely temporary and till the regular principal is posted on the said institute by the government. Now, last paragraph. From the records, it is seen that the departmental respondents neither considered the seniority and merit of the incumbents, including the petitioner as well as the respondent number 3, but only on the recommendation of the local MLA of Dudhnoi constituency dated so-and-so and verbal telephonic instruction of the departmental minister, the official respondents by order dated so-and-so allowed the respondent number 3 to hold the charge of in charge principal Diet Gwalpara Dudhnoi, though she is much junior to the petitioner, which is apparently on extraneous consideration, and therefore the same being bad in law cannot sustain, more particularly when there is a statutory 2010 rule in force under Article 309 of Constitution of India with regard to promotion to the post of principal Diet in Assam. It is also seen from the records that no gradation list of senior lecturer Diet of Assam has been prepared by the official respondents as required for promotion to the post of principals in Diet as per 2010 rules. In view of the above, the order under number so-and-so passed by the respondent 1 and 2, the state government in elementary education department and director of SCERT Assam respectively allowing the respondent number 3 to hold the charge of principal Diet Gwalpara Dudhnoi being illegal, bad in law, in the bad in the eyes of law, and hereby set aside and quashed. The respondent number 1, Commissioner and Secretary of Government of Assam Elementary Education Department shall fill up the vacant post of principal Diet in Diets of Assam, including Diet Gwalpara Dudhnoi, by following the provisions of the said 2010 rules at an early date. Look, there was no argument made that we are making here that there is a qualification prescribed by the NCT for the post of principal, and the state are bound to follow the qualification prescribed by the NCT regulations. No such arguments was advanced. Lordship is aware with the law laid down by Honorable Apex Court that a little difference in facts can lead to a different conclusion. There was no ratio laid down. A senior dispute was raised with regard to in chargeship, and in that context, this Honorable Court has come to a conclusion that you have to follow the Diet rules of 2010, seniority cum merit, and you are to appoint persons, senior lecturers, in accordance with their seniority position in the post of in charge, and also fill up the post regular principal. That is with regard to the criteria of seniority cum merit. I am advancing an argument that if you want to appoint a person as principal of Diet, you are duty bound to follow the qualification provided by the NCT regulations. It is incumbent upon you. You cannot deviate. Otherwise, it will be a repugnancy. Your rules are framed under the 309 cannot be counter to the NCT regulations under the NCT Act. And your Lordship will kindly appreciate how the department took into consideration this direction, how in fact they have misutilized this order passed by this Honorable Court, my lord. DPC minutes, my lord, will kindly take. Page 141.
But this is in dispute. The NCT says NCRT says that there is no such minutes.
Yes.
If there is no such measure,
So-
there is no point referring to it.
In my humble submission, my lord, this minute exists. I am disputing their contention, my lord. This minute exists, my lord. I'll substantiate before your lordship. So in this minute, they say,
I'll take a break and come back.
my lord. I'll just like to refresh your lordships with the affidavit in reply that I filed. Page 192. Lordships has already marked this. Just recapitulating before your lordships, my lord. To demonstrate that the diets will not impart both DLED and B.Ed, my lord. Yes, my lord, that's true. And if they don't follow the regulations, there are penultimate provisions that their recognition will be cancelled. Page 193 and 94. Now, my lord, I'll just rely on a judgment of the Honorable Apex Court, my lord. On the last occasion, I gave the certified copy. 2013 2 SEC 617, my lord. This judgment, my lord, emphatically discussed what is the role of NCT in, my lord, maintaining norms and standards of teachers' education system in the country, my lord. Before that, my lord, I just place before your lordships the 2014 regulation, my lord. Okay, my lord got. My lord, I have annexed in the petition only the relevant portion, that is annexure 4 of the regulations. This is the original regulation, my lord. So lordship may require to know, may want to know what is the regulation is all about. The annexure which I am relying to demonstrate the principal master PhD is part of this regulation, my lord. I have only annexed in the relevant portion in the red petition, my lord. I am giving the first 6 pages. My lord, lordships got the judgment, my lord. Yes. Para 36, my lord. Although I'm relying on basically, my lord, para 59, 60, 62, and 82, but I'm just reading para 36, which gives, my lord, a vast idea what is the role of NCT in the maintaining the teachers' education training system in the country, my lord. That's why I'm reading this paragraph. For regulation and proper maintenance of norms and standards in the teacher education system, and for all matters connected therewith, it was considered to establish a Central National Council of Teachers Education, for which purpose the Indian Parliament enacted the National Council for Teachers Education Act 1993. NCT was to be established in terms of Section 3 of the Act and was to consist of persons specified therein. For the purpose of present case, we are required to refer to certain provisions of the Act. The first relevant provision, which can be referred to in Section 12 of the Act, which states the functions that are to be performed by NCT, Section 13 places an obligation upon NCT to conduct inspection of the institute in prescribed manner. Other very significant provision in section 14 was 14 that deals with recognition of institutions offering course or training in teachers' education. One of the important powers of NCT is the power of delegated legislation as contained in section 32 of the Act. We shall deal with this provision along with some other relevant provisions in some detail. Under the scheme of the Act, in terms of section 12, it shall be duty of NCT to take all such steps as it may think fit for ensuring planned and coordinated development of teachers' education. As per the preamble of the Act, it has to lay down guidelines for compliance with recognized institutes for starting new courses of training and for providing physical and instructional facilities, staffing pattern and staff qualification amongst others, to examine, review periodically the implementation of the norms, guidelines, and standards laid down by NCT, and to suitably advise the recognized institutions, and foremost, it must ensure prevention of commercialization of teachers' education. For the purpose of ascertaining whether the recognized institutes are functioning in accordance with the provisions of this Act, the Council may cause inspection of any such institution to be made by such person as may direct and in such manner as may be prescribed. A complete procedure has been provided under section 13 for conducting inspection of the institution. After coming into force of the Act, every institution offering or intending to offer a course or training in teachers' education on or after the appointed day may, for grant of recognition under the Act, may make an application to the regional committee concerned in such form and in such manner as may be determined by the regulations. Section 14(3)(a) provides the scope and requirement for establishing such institution. The recognition must be granted by an institution when it has adequate financial resources, accommodation, library, qualified staff, laboratory, and it fulfills such other conditions required for proper functioning of the institution for a course or training in teachers' education as may be determined by regulations and upon such condition as may be imposed. If an institution does not satisfy the requirements of section 14(3)(a), the Council may pass an order refusing recognition to the institution for reasons to be recorded. Such grant or refusal has to be published in official gazette and communicated in writing to the institution and to the examining body or state government concerned and the central government in accordance with section 14(4). Section 14(6) will be of some significance once we deal with the facts of the present case, as it is a provision providing interlink between recognition of an institution by NCT on the one hand and affiliation by the examining body on the other. Now, para 41. The institution which does not comply with the terms and conditions imposed or contravenes any terms and conditions subject to which the recognition was granted, any regulation order made under the Act and or any provision of the Act, NCT may withdraw recognition of such recognized institution for reasons to be recorded in writing under section 17(1), subject to compliance with the conditions stated therein. Once the recognition is withdrawn, the following very serious consequences follow in terms of section 17(3) of the Act. Such institutions shall discontinue the course or training in teachers' education. Number two, yes, my lord, I'm just referring this to demonstrate the risk the state is running, my lord. The risk the state is running by not adhering to the NCT regulations and doing things at their whims and fancies. Now, if your lordships, now the paragraph 40 onwards is, my lord, with regard to the power and functions of NCT and how the NCT functions and what will be the implication if the NCT regulations are violated. Now, I'll just take your lordship para 59, my lord. The point I'm trying to make out is that, my lord, if there is repugnancy and if the state doesn't follow the NCT regulation, then the consequences, as well as it is the mandatory duty of the state, because it's an entry under item 66, schedule 7, the state is duty bound to give way to the central legislation, that is the regulation. Para 59, the above enunciated principle clearly shows that the Council is the authority constituted under the Central Act with the responsibility of maintaining education of standard and judging upon the infrastructure and facilities available for imparting such professional education. Its opinion is of utmost importance and take precedence over the view of the state as well as that of the university. The department of the state concerned and the affiliating university have a role to play, but it is limited in its application. They cannot lay down any guideline or policy which should be in conflict with the central statute or the standards laid down by the central body. The state can frame its policy for admission to such professional course, but such policy again has to be in conformity with the directives issued by the central body. In the present case, there is not much conflict on this issue, but it needs to be clarified that while the state grants its approval and the university its affiliation for increased intake of seats or commencement of a new course and college, its direction should not offend and be repugnant to what has been laid down in the conditions for approval granted by the central authority or council. What is most important is that all these authorities have to work in idem as they all have a common object to achieve, i.e. of imparting the education properly and ensuring maintenance of proper standards of education, examination infrastructure for betterment and educational system. Only if these authorities work in coordinated manner and with cooperation will they be able to achieve the very object for which these entities exist. Para 60. The NCT Act has been enacted by Parliament with reference to Schedule 7, List 1, Entry 66 of Constitution. There is no such specific power vested in the state legislature under Schedule 7, List 2. Schedule 7, List 3, Entry 25 is the other entry that provides the field for registration for both the state and the center in relation to education, including technical education, medical education, universities, vocational and technical training of labor. The field is primarily covered by union list, and thus the state can exercise any legislative power under List 3, Entry 25, but such law cannot be repugnant to the central law. Whenever the state law is irreconcilable with the central law, the state must give way in favor of the central law to the extent of repugnancy. This will show the supremacy of the central law in relation to the professional education, including the teacher training programs. And thereafter, my lord, the Medical Council of India versus State of Karnataka, my lord, para 27 and 29 has been referred to by the Honorable Apex Court. It is on the same line with regard to the Medical Council of India. Now, para 62, my lord. The Honorable Apex Court relied on that case of Satyapal Reddy, wherein Miller 213 of the Motor Vehicle Act was involved. The principle of repugnancy and its effect were discussed by this court in so and so. It is thus settled law that the Parliament has exclusive power to make law with respect to any of the matters enumerated in List 1 or concurrent power with the state legislature in Schedule 7, List 3 to the Constitution, which shall prevail over the state law made by the state legislature exercising the power on any of the entries in List 3. If the said law is inconsistent with the or incompatible to occupy the same field, to the extent the state law stands superseded or becomes void. It is settled law when the Parliament or the legislature derived a power under Article 246(2) and the entry in the concurrent list, whether prior or later to the law made by the state legislature. Article 242 gives power to legislate upon subject matter enumerated in concurrent list. The law made by parliaments get paramountcy over the law made by the state legislature unless the state law is reserved for consideration of the president or receives his assent. Whether there is any apparent repugnance or conflict between central and the state law occupying the same field and cannot operate harmoniously in each case, the court has to examine whether provisions occupy the same field with respect to one of the matters enumerated in concurrent list, whether there exists repugnancy between two laws. Article 254 lays emphasis on the words with respect to that matter. Repugnancy arises when both laws are fully inconsistent or are absolutely irreconcilable when it is impossible to obey one without disobeying the other. The repugnancy would arise when conflicting results are produced when both the statutes covering the same field are applied to a given set of facts. But the court has to make every attempt to reconcile the provisions of the apparently conflicting laws, and court would endeavor to give harmonious construction. The purpose of determining inconsistency is to ascertain the intention of the parliament, which should be gathered from the consideration of the entire field occupied by the law. The proper test would be whether effect can be given to the provisions of both the law, or whether both the law can stand together. Section 213 itself made the distinction of the power exercisable by the state government and the central government in working the provisions of the act. It is the state government that operates the provisions of the act through its officers. Therefore, subsection 1 of section 213 gives power to the state government to create transport department and to appoint officer as it thinks fit. Subsection 4 therefore also preserved the power. By necessary implication, it was preserved. It also preserves the power to prescribe higher qualification for appointment of officers of the state government to man the motor vehicle department. What was done by the central government was only the prescription of minimum qualification, leaving the field open to the state government concerned to prescribe, if it finds necessary, higher qualification. The governor has been given power under proviso to Article 309 of Constitution, subject to any law made by the state legislature, to make rules regulating the recruitment, which includes prescription of qualifications for appointment to an office or post under the state. Since Transport Department under the Act is constituted by the state government, and the officers appointed to those posts belong to the state service while appointing its own officers, the state government, as a necessary adjunct, is entitled to prescribe qualifications for recruitment, or conditions of service. But this is important, but while so prescribing, the state government may accept the qualifications or prescribe higher qualification, but in no case prescribe any qualification less than the qualification prescribed by the central government under subsection 4 of section 213 of the Act. In the later event, the prescribing lesser qualification, both the rules cannot operate without colliding with each other. When the rules made by the central government under section 213 and statutory rules made under proviso to Article 309 of the Constitution are construed harmoniously, there is no incompatibility or inconsistency in the operation of both the rules to appoint fit person to the post or class of officers of the state government vis-a-vis the qualification prescribed by the state government, by the central government under section 4 of section 213 of the Act. The facts involved in that case was that the state government prescribed higher qualification. Central government prescribed any minimum qualification. The persons approached the court saying that you have to prescribe only the qualification prescribed. You cannot prescribe higher qualification. In that context, the Honorable Apex Court observed that state can prescribe for higher qualification, no problem. But if it prescribes a qualification which is below the minimum qualification, then there is repugnancy. There will be apparent repugnancy and conflict. And in that event, state law has to give way to the central law. Now, para 66, yes, para 64, 66, 64. I'm sorry, 64, 66, 67. $69. Yes, ma'am. And lastly, 82. So, my lord, my humble submission is that uh, when the NCTA regulations has provided that a principal has to be a PhD and MA with 55% marks, state cannot deviate from them. That you follow 2010 rule or any other rule for the purpose of your other criteria like seniority cum merit, residency service, all these things. But when it comes to qualification, you cannot relax that qualification. You don't have authority. You are bound to follow. And consequence is that they have violated the regulations, and by the DPC minus that is 7/7/2023 promoted all underqualified senior lecturers to the post of principal, except one, serial number 5. She was a PhD and she was given promotion also before filing of the writ petition. For rest, they stopped at that point of time. In the meantime, we approached this honorable court, Milord. They were on the verge of passing order in their favor also. So, page 169, the minutes, Milord. Serial number 5, she was the only PhD person. So, you cannot give promotion to the post of principal to a senior lecturer who doesn't have seniority, Milord, PhD and MA with 55% mark. Whether I get by virtue of my seniority or not, that's a different thing, Milord. I am at serial number 128. There are only, Milord, I'll have the figures. There are diets, 27 diets, out of which 14 imparts B.Ed. So I don't know how you run your institution without B.Ed institution. You run that risk of appointing, Milord, underqualified principals in the delete, in the diets where delete is imparted. But so far as B.Ed is concerned, you are bound to follow this provision as per your own admission in the affidavit, wherein you have stated that it is applicable only for B.Ed courses. So 14 is diets are there wherein B.Eds is imparted. So I am entitled for that. I am at serial number 28. If all these 128, if all this, Milord, underqualified senior lecturer doesn't become eligible for promotion to the principal, Milord, my chances are there, Milord. I am only concerned that I get promotion. I am fighting the battle, Milord. Rest, Milord, the government, if government wants to run the risk that we'll continue with the underqualified senior lecturers or in charge or whatever manner, they can do it, Milord. But I am concerned with my promotion, Milord. So that is precisely my submission, Milord. If something is required, Milord, in reply, I'll just place. Much obliged.
Wait, please, Lord. I am appearing for the private respondents. Now, my first submission before Lordships is promotion, right to be considered for promotion is a right, not right to promotion. I think now that is fairly well settled. Now, in order to be eligible to be considered for promotion, the first requirement is the zone. No. Now, 17 posts were sought to be filled up. Therefore, my lord, 68 in the ratio of 1:4, 68, senior lecturer or vice principal are to be considered. And admittedly, the petitioner does not figure there because he is at serial number 128 of the seniority list. Therefore, my lord, this writ petition is an academic exercise. And the petitioner is aware of this requirement. Therefore, he has made statement in the writ petition in 2 different paragraphs. I'll draw your lordship's kind attention to that, where he tries to cover up the requirement of zone by saying since he has got the prescribed qualification of NCT, therefore her case should be considered. It's not that, that's not the position. If your lordship would kindly come to page 92 of the writ petition. This is the final gradation list, my lord. Page 92. this Rajen Datta, Nasimuddin Ahmed, then Dr. Nirupama Barik Saikia, Biman Chandra Datta, Mrinal Chaudhuri, Rupnath Das, Daisy Gogoi, Olokesh Datta, then Kishore Kumar Das, Lavanya Kumar Das. These have been, my lord, recommended by the DPC. Now, my learned friend's name in the seniority list is at page 97. Dr. Sapna Sikha Chaudhary, 128. So she is clearly not within the zone of consideration. Therefore, a person who is not in the zone of consideration, he or she cannot claim any right of consideration, whatever may be the requirement, my lord. So at the instance of writ petitioner, this writ petition is not maintainable. These are all settled proposition of law, my lord. I don't think I need to come up with any authorities on this point. Now, my lord, the second point is, there is a set of rules, that is rules of 2010. And pursuant to, my lord, the NCT notification of regulation of 2017, the state also issued a notification where they have partially adopted the recommendation of the NCT. These two, the rule as well as, my lord, notification dated 5/12/20 are not under challenge. If it is the petitioner's case that the prescription in the rule is repugnant to the prescription in the NCT, then, my lord, repugnancy does not follow automatically. It has to be put to challenge, where the matter will go before the Honorable Division Bench of this Honorable High Court, where the Honorable Court will decide whether this is repugnant or not. So that is not done. So rules is not under challenge, notification is not under challenge. Yes, my lord. 5/12/20 at page number 127, where the NCT recommendation was partially adopted by the state. That has to be challenged. That is not under challenge. (127). This, whereas education being the subject of concurrent list and NCT being the statutory body of the Government of India for teachers' education, has prescribed norms of teachers' education course as well as qualification of the teachers' education as per NCT norms and standard. Most of the fund in this regard is being borne by the Government of India for conducting teachers' education program, sustaining NCT recognition. Keeping above in view, Governor of Assam is pleased to revise the existing minimum qualification for all categories of post of District Institute of Education and Training, Government BT colleges, College of Teachers Education, and State Council of State Educational Research and Training as per the norms and standards prescribed by NCT as follows. So, my lord, for the post of lecturer, now they have introduced the requirement. Perhaps the idea is, my lord, the adequate number of PhD holders and MAd with 5 years of experience are not available. Number one. Secondly, my lord, maybe the government was of the view that prospectively will apply this requirement. Henceforth, whenever any recruitment to the post of lecturer would be made, they will insist on that qualification. But all of them, those who are already in service, in respect of them, the state's policy is, perhaps, my lord, conscious policy is not to adopt the NCT regulation. Now, this is permissible, my lord. There are Supreme Court judgments and our High Court judgments also there on this point. So this is the point, my lord. So these are not under challenge. Therefore, lordships will not issue a writ of certiorari saying that this rule is repugnant to the NCT regulation without being a challenge laid to it. Now, my lord, precisely this question arose in my lord Kalyani Motivanand's case. If your lordship would kindly have 2015 6 SCC 363. 2015 6 SCC 363. I'll rely on paragraph 62. 2015 6 Supreme Court cases 363. Kalyani Motivanand versus KV Jayaraj. It was in the context of, my lord, UGC regulation. Yeah, Lordship got the judgment. Yes. It reads like this, para 62.1. To the extent state legislation is in conflict with the central legislation, including subordinate legislation made by central legislation under entry 25 of the concurrence list, shall be repugnant to the central legislation and would be inoperative. The UGC regulation being passed by both the houses of the parliament through a subordinate legislation has binding effect on universities to which it applies. This is important. To which it applies. The UGC regulation of 2010 are mandatory to teachers and other academic staff in all central universities and colleges thereunder, and institutions deemed to be universities whose maintenance expenditure is made by UGC. 62.4. UGC regulation 2010 are directory for universities, colleges, and other higher educational institutions under the purview of the state legislation, as the matter has been left to the state government to adopt and implement the scheme. Thus, UGC regulation 2010 are partly mandatory and is partly directive. So, my lord, in respect of UGC regulation recommendations, there was a dispute as to whether these are ipso facto these would apply. The Honorable Supreme Court was of the view, in respect of central universities and institutions under central universities and deemed universities, yes, this is mandatory. The requirement is imperative. But in respect of state universities or institutions under the purview of the state legislature, there is a requirement of adoption by the state government. In fact, my lord, the similar argument I advanced before this honorable court, which my learned friend is advancing, in case of a Guwahati University selection of vice chancellor. It was negative by single bench and division bench relying on Kalyani Motivanand. The judgment is, my lord, 2019 SCC Online Guwahati 3470. The argument which my learned friend is advancing, I also advanced, but it was rejected by this honorable court. 2019 SCC Online Guwahati 3470. Paragraph 20 and 30. My lord, Professor Arsana Sharma versus University Grants Commission and others. At para 29, Lordships will notice that Kalyani Motivanand judgment is quoted. Then para 30. Supreme Court to quote konse, there are 29 or 30 is the judgment. From the above, it is seen that on the basis of clause so and so of appendix dated so and so, read with regulation 740, it was held by the Honorable Supreme Court that scheme of regulation is applicable to teaching staff of all the central universities and colleges thereunder, and institutions deemed to be universities whose maintenance expenditure is made by UGC. However, the scheme under the regulation of 2010 is not applicable to teaching staff of universities, colleges, higher educational institutions coming under the purview of the state legislature unless state government wish to adopt and implement the scheme so and so, subject to terms and conditions mentioned therein. It was also held that regulation 7.3.0 has to be treated as recommendatory insofar as it relates to the universities and colleges under the state legislation. Once regulation 2010 is adopted by the state government, state legislation has to be amended appropriately. It was also held that in the context of the case under consideration, that regulation 2010 having not been adopted by state of Tamil Nadu, in Kalyani Mathivanan, my lord, state of Tamil Nadu did not adopt. The question of conflict between the state legislature and statutes framed under the central legislation did not arise. It is thus clear that UGC regulation is directory for the universities, colleges, and other higher educational institutions under the purview of the state legislature, as the matter has been left to the state government to adopt and to implement the scheme. It appears that once state government adopts this scheme, UGC regulation will be mandatorily applicable. It is in this context, Learned Counsel for the parties laid emphasis on the question as to whether scheme was adopted by the state government or not. In fact, my lord, Learned Advocate General appeared in this case and he made a statement that we have not adopted. Therefore, my lord, the case was given a quietus and the judgment of the learned single judge was upheld. So this is the case, my lord. And my learned friend is relying upon that, my lord, minutes of that DPC, saying that one-time measure. But is it the function of the DPC to decide what should be the qualification? DPC's role is to make selection based on the existing rule, whatever the rule is. Rule may be good, rule may be bad. It is none of the business of DPC to give comment on, my lord, which rule is applicable. So, my lord, it's a very short matter that way. Number one, the petitioner is not within the zone of consideration. He is, because a right to be considered for promotion is a right. There is no right to promotion. So right to consideration will arise only when you are within the zone. You are not in the zone. 17 posts were sought to be filled up. So as per the rules, my lord, 68 persons are to be considered. That way he was not within the 68. In any case, there were other doctorates who could have approached this honorable court. They have not done it. Therefore, it is not a PIL. She can't be pursuing a PIL. Number one. Secondly, my lord, I have already said the rules of 2010, which has modified by this notification of 2010, where it partially adopted the NCT regulation, that is not under challenge. So in the absence of challenge being laid to these two rules and notification, my lord, how can lordships issue a writ of certiorari or even to make a declaration that the rules are repugnant to the NCT regulation? It does not evolve in thin water, thin air. It has to be, there has to be a foundation laid, and my lord, the challenge has to be laid. And thirdly, I have demonstrated, my lord, the position in law. So it was a conscious decision of the state, maybe having regard to the the scarcity or paucity of the people with, doctorate and MAd with 5%, 5 years teaching experience. They decided to apply it prospectively. Whosoever will enter service after 2017, they must have this required qualification. And the otherwise, those who are existing, their condition of service will be governed by the 2010 rules. That being the position, I don't think, my lord, there is anything in this writ petition. She can't be pursuing a public interest litigation, my lord, by proxy. And my lord, if we go strictly by the writ petition, If your lordships will kindly come to para 19, the petitioner herself is aware of the position and she says so. Please come to page 16, my lords. Page 16, the subpara. Therefore, as per rules of 2010, a vice principal or senior-most lecturer having 10 years of experience as lecturer, senior lecturer, vice principal is entitled to be in the zone of consideration for promotion to the post of principal of the diet. In this context, it is pertinent to mention here that the post of vice principal or senior lecturer are equivalent posts. Therefore, petitioner having more than 10 years of experience as lecturer, senior lecturer fulfills the eligibility for promotion. This is wrong. This later part is wrong because she is not within the 68. So there, but otherwise, she also says that a vice principal or senior most lecturer having 10 years of experience is also entitled to be in the zone of consideration. And the concept zone of consideration is not alien to the petitioner. She is conscious of it. So therefore, my humble submission is, my lord, this selection has been made properly in accordance with the rules and policies of the government. And if the petitioner was aggrieved, then she has to lay a challenge to all this. Otherwise, I don't think lordships can record any finding on it. So state has decided not to adopt it. State has decided to adopt it partially, and it has been adopted. And my lord, if there are certain consequences provided in the NCT Act, those are there. If law takes its own course, it will do, but not at the instance of the petitioner who is not even in the zone of consideration. So that being the position, my lord, my humble submission is this recommendation was quite old, my lord. Lordship, there's a stay order operating only in respect of 2 persons who are on the verge of retirement. Lordship was pleased to relax that rules, modify the interim order. That is how 2 of the, recommendee were promoted, but rest are all held up. So my humble submission is, my lord, it should be, Lordship would vacate the interim order and dismiss the writ petition because there is absolutely nothing in this case. And she can pursue a PIL in the name of, my lord, a writ petition. In effect, it's a PIL because the rule of rule of locus standi has to be relaxed in this case because she is not in the zone of consideration. That is my humble submission.
Wait, wait. Well, appearing for response number 1 and 2, my lord, the primary challenge in the repetition is the minutes of the DPCO. The page 120. Sorry, page 27 is the prayers, my lord, in the repetition. My lord. In respect of the third prayer, my lord, the consideration for the representation to the 24/3/2023. This has already been considered, my lord, by the order that we have annexed in our affidavit at page 160. The objection that has been raised by the petitioner in respect of the provisional gradation list has been met, and page 160 in the affidavit 30th June 2023 is the order, my lord. Page 160. My lord will find the name of the petitioner at page 162. Her objections. And after meeting the objections in the to the provisional gradation list,
the final gradation list was published on 36/2023. There is no challenge to the final gradation list, my lord, in this writ petition.
Is that?
Page 162, serial number 11, my lord.
Yes, but what is the reference to this representation?
My lord, the representation is at page 160. Oh, sorry, my lord. Her representation is page 83. This is basically an objection against the provisional gradation list that was published on 18 March 2023.
Yes.
And there were other objections also from various other candidates. And all these objections were met by this order at page 160. And thereafter, the final gradation list of 36/2023. Page 90 is published, my lord. And there is no challenge to this final gradation list, my lord. Now, if your lordship takes
Which page is final gradation list?
final gradation is at page 90 of the writ petition. List starts from page 92.
Yes.
Final. Now, my lord, the Departmental Promotion Committee, my lord, following the rules of 2010, my lord, which is applicable for promotion, my lord, has recommended the names of the private respondent based on seniority come merit. Now, my lord will kindly have a look at the rules, my lord, for a moment, my lord. Page 99 is the service rule, my lord, which governs the promotion to the post of principal, my lord. Rule 5, page 100, is the provides the method of recruitment, my lord.
Just one. Yes.
My lord. Rule 5, Roman 1, my lord, to find principal. The post of principal shall be filled up by promotion from the select list of vice principal, senior lecturers having not less than 10 years of experience as senior lecturers or vice principal. Now, Roman 3 is in respect of lecturers, my lord. Kindly find the post of lecturers shall be filled up by direct recruitment except education technology stream branch. And now, my lord, the academic qualification. My lord, sorry.
Yes, after page 100.
My lord. So from rule 5, my lord, principal and vice principal are promotional post and lecturer is a direct recruitment, except the education technology stream, my lord. Now rule 8, my lord, 101, page 101, prescribes what would be the qualification, my lord.
Yes.
The academic qualification of a candidate for direct recruitment shall be as prescribed by the governor appointing authority in consultation with the commission from time to time. The qualification and experience prescribed as on date of commencement of these rules are given in schedule 2. So in respect of direct recruitment, it is the governor who can, the government who can prescribe the qualification. Now, Rule 11 provides that Rule 11 and Rule 12 are the manner how the promotion will be made. And this I am showing because it clearly indicates that the principal and vice principals are promotional posts. Now, page 127, the notification of 5/12/2020.
Page 127.
Page 127. For the post of lecturer, the state has adopted the NCT prescription, as it is a direct recruitment post.
Yes.
So, the PhD and MAd 55% was never a qualification throughout the diet colleges, for the diet even for the direct recruitment to the lecturer post also. After the NCT has prescribed in 2014, only in respect of the lecturers, the state has adopted it, not for the promotional post. As on today, the DPC has rightly followed the rules because which does not provide the qualification of PhD and MAd for the promotion. And page 127, the notification adopting the qualification prescribed by the NCT only in respect of direct recruitment for lecturers has not been put to challenge in this repetition.
Okay, continue to.
And my lord, the page 141,
Continue to.
At two lordship, there is another matter in a division bench, little accommodation.
So I tried to show from the rules that there is no ambiguity as to that the principal and vice principal posts are promotional. And the only eligibility criteria is that 10 years experience as a senior lecturer, or as a vice principal. Rule does not prescribe any such qualification as has been prescribed by the NCT regulation. Now, the NCT regulation of 2017, consciously the government has adopted on 5/12/2020 only in respect of the direct recruitment post of lecturer, in order to avoid the casualty that may occur to the existing employees, because the PhD, MAd, these were never a qualification for any of the posts, even for direct recruitment. And the decision of the state government, I pointed out that as Rule 8, the government has been given the power to prescribe the qualification that is required for a direct recruitment. And the notification of 5/12/2020 is the notification that is issued by the government prescribing the qualification for direct recruitment. This is the decision of the government, not adopting the NCT regulation 2017 for the post of promotional post, my lord. And that decision is not a subject matter of challenge, my lord. On the contrary, my lord, the petitioners are relying on this notification to show that the government has adopted NCT regulation 2017.
Please come to it again.
My lord. My lord, the rules, my lord will find the rules at 101,
Yes,
page 101,
yes.
rule 8, my lord. Empowers the government to prescribe the qualification in consultation with the commission from time to time for direct recruitment posts. Now, under the rules, my lord, the lecturer is a direct recruitment post. May I read rule 8, my lord?
No, it's okay.
My lord. So, under the rule 5, sub rule 3, lecturer is a direct recruitment post.
Yes.
My lord. So, the notification at page 127 dated 5/12/2020 the notification 5/12/2020 purposefully and consciously, my lord, the government has adopted only in respect of directly the post of lecturer, so as to, my lord, that it not prejudice the existing employees their right to the promotional post, my lord. Now, my lord, in respect of the minutes which was pointed out at page 141, my lord, our categorical stand in our affidavit that is that there is no such minutes 4/2/2021 wherein an exemption was taken as a one-time measure. On the contrary, my lord, the minutes is of 12/2/2022. That, my lord, will find at page 163, my lord. That was the DPC of 12/2/20, minutes of 12/2/2023. There was no such DPC held on 4/2/2021.
Yes.
Page 163 is the minutes, my lord.
Yes.
And here, my lord, will find that in 164, in serial number 15, the person, my lord, Jasimuddin Sheikh, who was the petitioner in that petition, my lord, 2239 of 2019, wherein this honorable court directed to go ahead with the promotion following the 2010 rules. And pursuant to this, DPC, my lord, 25/2, page 167 is the notification promoting all these candidates to the post of principal. One of the petitioner also
Yes.
my lord. The petitioner also tried to rely on page 124 of the writ petition to project, my lord, that for diet, the SCRT has directed that the B.Ed is mandatory, my lord. Whereas, my lord, this communication to all the principals is only for the purpose of giving an exemption to the candidates who, the persons who have PhD under 2010 rules. In lieu of PhD, the net will be net, their exemption to the net, my lord. Your lordship will find in the last paragraph, last line, my lord, provided the candidates who are have been awarded PhD degree in accordance with the University Grant Commission 2009 shall be exempted from requirement of clearing net for the appointment of assistant professor and equivalent position in the universities or college institution. This was only in respect of giving an exemption to net, my lord, in lieu of PhD under 2009 regulation.
Yes.
So my respectful submission, my lord, that until the NCT regulation of 2017 is adopted by the government and the rules, the service rule in force, that is 2010, is amended, my lord. No, DPC cannot be faulted for not taking that prescription into account, my lord. Because the service rule, my lord, provides that it's a promotional post, the qualification has been duly taken into consideration, and the recommendation has been made as per, my lord, seniority cum merit. My lord, the impugned minutes, it is not a part of the writ petition, my lord. Your lordship will find that in page 169 of my affidavit.
Just a moment.
Well,
Yes.
Your lordship finds page 169. That is the minutes, my lord, which is with the calendar.
Yes.
And my lord will kindly take up my affidavit for a moment. My categorical stand in the affidavit at para 8 and 9.
Yes.
7, my lord, we have indicated the provisions of the service rule, my lord. Now, in 8, my lord, in view of the above extant rules of service rules of 2020, there is no ambiguity as to the post of principal of diet is a promotional post which are yet to be filled up from the post of vice principal, senior lecturer having experience as prescribed. The service rule 2020 nowhere mandates that the vice principal, senior lecturer must possess PhD degree for the promotion to the post of principal. Further, it is necessary to mention that the PhD was never a prescribed qualification for the post of lecturer, senior lecturer, vice principal, and not to mention even principal for that. That the answering department begs to submit that, however, after coming into force of NCT Regulation 2014, as amended on 2017, the government of Assam has issued notification dated 5/12/2020 by revising the existing minimum qualification for all categories of post of diet, government BT college, college of teachers education and SCRT as per norms and standard prescribed by the NCT. The minimum qualification for the post to be filled up by way of direct recruitment through APSC only was revised, is not for promotional posts as like principal, vice principal, senior lecturer of diet. So, well, that's all, my lord. Because DPC, my lord, unless it is the rules are amended, this are adopted, my lord, the DPC do not have the power to go into all these aspects. And the primary challenge in the writ petition is that the recommendation of DPC recommending unqualified candidate, and which basis the basis of unqualified saying it unqualified is 2007 regulation. Padmana. What would you? What would you? That's obliged.
In this paper, I'm preparing for SCRT.
Or SCRT, okay.
Basically, I'm adopting the stand of the government because it pertains to the government only. In this matter, Lordship, I have also filed my affidavit, Lordship. I'm referring to paragraph 11 of that affidavit. Yeah.
Para 11.
Para 11 of that affidavit, page 204.
Same thing.
Same thing, Lord, nothing. Obliged, Lord.
Yes, sir.
Well, so far as item number 1 is concerned, my lord.
Yes.
Number 1, my lord, the petitioner in the gradation list, his position is 36, my lord. As per gradation list stated 31/5/2023. Now, as per today, I have come to know he has, in the meantime, he has been upgraded also. And now the vacancy position is 25.
You are upgraded to what post?
I'm serving as the senior lecturer, my lord, in the Diet Kachar, my lord, and presently holding the charge of the principal also. Therefore, he may come within the zone of consideration, my lord, against 1 is to, if or against 1 post, if 2 persons are considered, my lord, he will come in the zone of consideration. He is having the PhD degree also. He earlier approached this honorable court, my lord, and this honorable court earlier opposition directed to consider his candidature for the post of promotion, my lord, annexure 4, page 35.
Page
35 of the petition, my lord, this petition, annexure 4, my lord. But at that point of time, he was in the much lower in the gradation, position was in the much lower in the gradation list, my lord, in the year 2020, my lord. So he was in that round of consideration, he was left out. Presently, my lord, he will come within the zone of consideration.
I just, like, just 2-3 points of my senior, my lord. First of all, my senior counsel, Mr. Chaudhary, made a submission that first requirement is the zone of consideration. That I'll have to be in the zone of consideration. Then only I'll be, I'll get my right of consideration will crystallize. So this writ petition is not maintainable. My lord, the rule says zone of consideration of qualified person, my lord. First, I'll have to be qualified. One has to be qualified. Then he will be taken into the zone of consideration. Zone of consideration is not taken only because the person is senior. He has to be qualified. So in my case, my lord, since I have the PhD, my lord, I come into the zone of consideration. I qualify the NCT regulations and I come into the zone of consideration. So my writ petition is maintainable. Second submission is made that rules and the notifications not under challenge. Milord, here I'm developing a case that NCT guidelines or NCT regulations being binding on the state government, Milord, you cannot deviate from the regulations of the NCT. So you are to follow, you are bound to follow. In the next limb, a submission has been made that state has taken a decision not to adopt NCT. Now that policy decision is nowhere there. The Council for the State Government also made a submission that we have, as informed my colleague, that they have not adopted the NCT regulations, Milord. Where is that decision? It cannot be your.
Once somebody says that I am adopting X, that means Y is not there.
I'll come to that, Milord. Now, the genesis of that submission is that they will have to adopt. And for that purpose, Milord, a Supreme Court judgment has been relied on, wherein UGC regulations are there. Now, I'll just take your lordships to that judgment 2015 6 SC 363. Milord, this judgment is distinguishable on the facts of it, Milord, because in UGC guideline, if I take your lordships to paragraph 56 and 57, that was not placed before your lordships. The sum and substance is that there was a provision in the UGC guidelines that state or universities will have to adopt it. The reason is that UGC do not fund the universities or the institutions. It is the property of the state. So that, Milord, provision is not there in the NCT regulations. So there is no question of adoption, Milord. You are bound to follow the NCT regulations. Page 56. Sorry, para 56, Milord. Supreme Court judgment. Oh, paragraph to this. The citation is Milord 2015 6 SCC 363.
Yes.
Para 56, Milord. We have noticed and held that the UGC regulations 2010 are not applicable to the universities, colleges, or other higher educational institutions coming under the purview of the state legislature unless the state government wish to adopt and implement the scheme subject to the terms and conditions therein. In this connection, we may refer to para 8P5 Roman 5 of Appendix 1 dated so and Regulation 7.4.0 of the UGC Regulations 2010. I'll take your lordships to these provisions. Now, para 57. It is also not the case of the respondents that the scheme contained in Appendix 1 of the Annexure of UGC Regulation 2010 has been adopted and implemented by the state government. It is also apparent from the face of from the fact that the University Act has not been amended in terms of the UGC Regulation 2010, nor was any action taken by UGC under Section 14 of the UGC Act 1956. As a consequence of failure of the university to comply with the recommendations of the Commission under Section 14 of the UGC Act 1956. Now, Lordship will kindly come to para 33. That will be page, my lord, 380, but my lord will kindly come to page 382, that clause 7.4.0. which has been referred to in para 56.
Yes.
Page 382, 7.4.0. The university state government shall modify or amend the relevant act statutes of the universities concerned within 6 months of adoption of these regulations. So there was a provision that state governments and universities has to adopt. Now the another provision is page 30, para 35.
Yes.
Just above para 35, my lord, the clause 8. 8P4 has been quoted, my lord. And it is said from para 8P1 and 5 of Appendix 1 dated so and so read with regulation 7.4.0, we find that the scheme of regulation is applicable to the teaching staff of all the central universities and colleges are thereunder, and the institutions deemed to be universities whose maintenance expenditure is made by the UGC. However, the scheme under the UGC Regulation 2010 is not applicable to the teaching staff of the universities, colleges, and other higher educational institutions coming under the purview of the state legislature, unless the state government wish to adopt and implement the scheme subject to terms and conditions mentioned therein. No, there is a provision for adoption in the scheme itself, regulation itself. That's why Supreme Court has come to a conclusion at para 62. Now, in the NCT regulations, my lord, I have given in the morning hours 6 pages of the NCT regulations, apart from the annexure that I have, annexure 4 that I have quoted in the annex in the writ petition. Lordship will minutely go through each and every paragraph of those 6 pages. Lordship will not find anywhere giving power of adoption to the state government with regard to these institutions, my lord. The judgment that I relied on that is 2013 2 SCC 617. So firstly, 2015 6 SCC 363, my lord, absolutely distinguishable in the present facts of the case. Now the judgment I relied on, that is 2013 2 SCC 617, this is directly on the issue of NCTE, implications of NCTE regulations. And para 67, your lordships, I have already said to your lordships, 67 and 69 clinches the issue, my lord. You don't have any power of adoption. You are bound to follow it. Whether they call it a repugnancy or else. But the fact of the matter is that you cannot go beyond whatever has been provided by the NCT regulations. Now, my friend appearing for the state government, my lord, almost made the similar submissions like the senior counsel, Mr. Chaudhary, has said regarding adoption, my lord, that already clarified. Zone of consideration also, my lord, that I have clarified. Now, one submission has been made that the DPC minutes dated 4/2/2021, which is the issue, there is no minutes as stated in 4/1/14, para 14, DPC minutes held on 4/2/2021. My lord, here I would like to clarify this issue. Now, I'll just place before your lordships how the they say they don't know about 4/2/2021. There is an order of this honorable court wherein that 4/2/2021 has been quoted. So this is falsification of facts, my lord, on affidavit before your lordships.
Give the citation to him.
Yes, my lord, I am giving a copy to him. The petitioner is a senior lecturer in the District Institute of Education and Training, and for the purpose of promotion to the post of principal in diet, the petitioner claims to be the senior most eligible senior lecturer. The candidature of the petitioner for promotion to the post of principal was also considered by the Departmental Promotion Committee held on 4/2/2021 in the office chamber of Commissioner and Secretary to the Government of Assam, Elementary Education Department, for filling up of 18 vacant posts of principal in the diet. The fourth paragraph of the minutes of the DPC held on 4/2/2021 refers to a judgment dated 9/4/2019 of this court in WBC so-and-so, wherein it was held that the post of principal of diets be filled up by following the provisions of Diet Service Rules 2010, not to make the new NCT guidelines requiring the qualification of PhD degree applicable for the purpose. Accordingly, the in the said selection, two other candidates, Srimati so-and-so, were selected for promotion as principals, although they did not have the PhD degree. It is stated that in the meantime, both the aforesaid two persons who were appointed as principal had superannuated from service, which has resulted in two further vacancies having arisen in the post of principal diets. The petitioner points out the requirement of earlier DPC of 4/2/2021 to include candidates without PhD was only a one-time practice. But in spite of it, the petitioner has raised an apprehension that in the forthcoming selection for the post of principal, the same practice may be followed and requirement of PhD may be ignored. Now they say that 4/2/2021 is not there, whereas it is part of this honorable court's order. Same thing, my lord. One-time relaxation was the decision, and here also the petitioner apprehended, because he was a PhD holder, that again they will fill up with non-PhD. And government has filed an affidavit that there is no existence of 4/2/2021.
Yes.
So in my humble submission, my lord, the respondents following the respondents overlooking the NCT regulations 2014 with regard to the qualification for the post of principal, holding a DPC by recommending persons who are underqualified, has committed a serious wrong, my lord. It is absolute violation of the NCT regulations, which they don't have any authority or power to violate. There is no power of adoption. They are to follow the NCT regulations in toto, because you get the money from central government, my lord. The diets are not funded by state. The entire money comes from the central government. State only regulates. So you will get the money from the state government. I will say that we will not follow the regulations of 2014 so far as principal is concerned. We will follow for lecturer. So lecturer will be a PhD, principal will not be a PhD. So far as principal is concerned, we will not follow. Look, that is completely wrong. So in my humble prayer, my lord, this DPC minutes that it's 7/7/2023 is required to be interfered. 7/7/2023 is required to be interfered, and the government should be given direction that you follow the regulations of 2014 so far as qualification for the post of principal is concerned. Thereafter, you do whatever procedure you follow, seniority cum merit or the DPC guidelines provided in the rules. So that is precisely my submission. Deeply obliged for the patient hearing.
And two. And this, P. Nayak, standing counsel for respondent number 3. And Mr. K. Chaudhary, the senior counsel, assisted by Mr.
My lord, S has recovered.
S. Hazarika, counsel for respondent numbers
6 to 14.
6 to 14. Arguments of agree, judgment reserved. Also, just read here. The K. Chaudhary. He has submitted that uh, on a query of the court relating to adding of the affidavit in opposition by respondent number 614 after the matter was part heard by order dated 14/5/2024. Learned senior counsel for respondent number 6 to 14 has submitted that he would not rely on this affidavit in opposition filed by respondent numbers 6 to 14. The order dated, no, sorry, which was filed on 3/6/2024. The after matter was heard and judgment reserved.
If my lord permits, my lord, I can, my lord, submit one written submission.
No,
If-
not after. You should have given.
Fine, my lord. If it's all right.
Spend my time.
No, it's all right. Just for lordship's assistance, my lord, if required. Fine. Deeply.
Mr. Dhar is here. Mr. Dhar, yes, you have to complete your submissions.
My lord, I have a very small submission, my lord. I have already submitted on the last occasion, my lord. Here I am just referring to the OM, my lord, that is there on, I have earlier, my lord, given a copy, my lord, 9th May 2006.
Yes,
My lord, I am just referring to the earlier that OM that I have already submitted before your lordship. 9 May 2006, the OM, my lord. I am referring to clause 2, my lord.
office memorandum of 9th May.
9th May, my lord.
Uh-huh.
My lord, clause 2, my lord. That I'm just reading again once, my lord. At the time of consideration of the cases of the government subject in zone of consideration for promotion, falling under the following categories should be specifically brought to the notice of the Department Promotion Committee, Selection Committee Appointment Authority, Government Servant under suspension. She is not, my lord. Government servant in respect of whom a charge sheet has been issued and the disciplinary proceeding are pending. And government servant in respect of whom prosecution for a criminal charge is pending. So, my lord, in this case, it seems that prosecution section has already been, my lord, given. So, on the last occasion, my lord has directed the registry to, my lord, send a scan copy of the charge sheet, my lord, to the additional CJM, my lord, Tinsukia. So since, my lord, prosecution sanction was given, my lord, that is why our DPC is in seal cover. That is what we have stated in our affidavit. Affidavit filed by respondent number 2, my lord. 2 and 4, both, my lord. So that is why, my lord, we could not. And rest, my lord, I am leaving with your lordship, my lord. Senior counsel has already argued his case, my lord. Yes.
My lord will find the procedural sanction, my lord. It's it was brought by the petitioner in an additional affidavit. That is in page number 40, running page 40, my lord. And 41 is the operative part. 41, my lord, the last paragraph. Dated,
Just a moment.
my lord.
Then. Maybe কোনো আছে অলরেডি লোক রেগুলো আছে যেটা কুড়ি কমপ্লিট অলরেডি বাইরে আছে don't take anything with the order sheet, huh? Very difficult. Okay, I was supposed to lobby assess and get order sheet. Thank you. Yes, please come again.
My lord, I have narrated the para 2 of the OM, my lord. that
Yes,
my-
yes.
Now, my lord, I'm coming to the prosecution sanction that has been given by the government, my lord. That is a part of the record in the additional affidavit filed by the petitioner in page number 40. It starts from 40. The page 41 is the operative part, the last paragraph.
Yeah, just one.
That is dated 21 November 2019. Now, therefore, I, Srimati such and such, Secretary to the Government of Assam Personal Department, do hereby accord sanction for prosecution of Srimati such and such. So on that day, my lord, the prosecution sanction was accorded in 2019, 21st November. And we stated in our affidavit, my lord, affidavit filed by the respondent number 2. Aisha?
What is the date of sanction of prosecution?
My lord, that is, my lord, 21st November 2019, my lord. That is in page number 41.
19.
My lord. 21 November 19. Page 41.
But still, Mr. Dhar, it can't be saved. The sanction, despite the sanction in 2019, the charge sheet was on 28/3/2022. So at that time, no criminal charges were pending against him. It has to be quashed.
But they are the prosecution sanction.
But that's okay, but that's not the law. Prosecution sanction without a charge sheet would not be a proceeding pending against him. That can't be construed.
Yes, my lord, clause 2, subclause 2, my lord, of the OM.
Well, there's a possibility it may not be uploaded today. By the time, yes, I start dictation, nothing will remain open.
Lordship may take time and comfortably.
No, we are not in comfort zone any longer.
The other day, when
That was a better comfort zone.
one judge, honorable judge from, I think, Allahabad court or Kerala court. And that after retirement, that he was giving a speech, not a rose petals. Judgeship is not a rose petals.
Obviously, my
No,
lord.
Mr. Das,
We understand
we
that.
live in a unique situation. You see, there are two concepts operating. On the Mr. G. Pegula and the government, CC has brought to the notice of the court that pursuant to order dated 10/5/2019, an additional affidavit has been filed by respondent number 3. First, on behalf of respondent number 3, by the Deputy Inspector General of Police, Group Center, CRPF Guwahati, on 4/2/2021. Next para, on a perusal of the said affidavit and documents enclosed thereto, the court does not find that it contains information and record as to how the information of referring the petitioner to IGP space NES, Shillong, for Departmental Rehabilitation Board -2011 was provided to the petitioner. Next, therefore, the Deputy Inspector General of Police, Group Center, CRPF within bracket, respondent number 3, is directed to comply with the directions contained in order dated 10/5/2019 and will cause production of the record as to how the information of constitution of a department, of a reference to DRB-2011 in respect of the petitioner was served on him. Next para. The learned CEC shall send a downloaded copy of this order to the respondent 3 to obtain instructions. Next para, list on. Give you 2 weeks time. It is 6th. On 21/6/2024.
21, I will not be available.
Will not be there. The 24/6.
25.
25 is Tuesday. I am reserving those
Oh,
days.
अच्छा. Okay.
You give this back.
Yes.
Raji. It's very close to vacation. No, 24.
24. Lovely. 24.
Oh, अच्छा, अच्छा.
There you go.
Oh, अच्छा.
28 is the last day of the court notification.
After the court. Okay, make it 26 then. 24, we have some other just fixed.
The 26. Lovely.
Item 15 with 16.
Please, Lordship, I'm in item number 15, Lordship. Otherwise, in this matter, Lordship, I couldn't contact the petitioner, Lordship, whether he would like to proceed with the matter or not. Lordship may fix the matter after 2 weeks, Lordship, by the time.
No, not after 2 weeks, we fix it after vacation.
Lordship.
We will not be able to take up.
In item number 15 only, Lordship.
No, but these are two tag together matters. We can't segregate.
Lordship.
Who is in the first matter?
Item number 15, I'm there. Then first matter.
No, this is item
Item 15, 1-5,
15, you are there.
Lordship.
And 16?
16,
Mr. M. Dutta, Lordship. M. Dutta.
Okay. Mr. P.N. Sharma, Learned Counsel in WPC 557
557.
of 2016. Praised for some time to enable him to obtain instructions as to whether the petitioner is interested to pursue this matter.
Lordship.
Mr. R.R. Govind, and standing counsel for the
Forest Department, Lordship.
Forest Department is present. Matter stands adjourned today. Just immediately after the ensuing summer vacation on a date to be fixed by the office. And in next item, item 16, you write. None appears on call for the petitioner. Mr. R. Govind, and standing counsel for the Forest Department is present. Next para. For end of justice, the matter stands adjourned today. List along with the corrected writ petition. Connected WPC 557 of 2016 immediately after the ensuing revision.
Lordship. Much obliged.
Lordship.
Item 17.
Wait, please, your Lordship. In this case, your Lordship, I was terminated from my dismissed from service, your Lordship. Your Lordship may kindly peruse page 52. Sorry, your Lordship, page 54. Page 54, the charge. Page 54, your Lordship.
52.
54, Your Lordship. May I read, Your Lordship? Article of charge, Sri Kandobo Kumar Kolita, Senior Manager, presently under suspension while functioning as branch head, Polton Bazar Branch, 1925 from 8/10/2012 to 16/11/2013, has allegedly committed several acts of omission and commission, details of which are mentioned in the statement of allegation for which Sri Kandobo Kumar Kolita is charged is under. Sri Kandobo Kumar Kolita has failed to take all possible steps to ensure and protect the interests of the bank and discharge its duties with utmost devotion and diligence, which is violative of Regulation 3(1) of the UCO Bank Officers Employees Conduct Regulation 1976 as amended. Kandobo Kumar Kolita has acted in a manner unbecoming of a bank officer, which is violative of Regulation 3(1) of the Officers Employees Conduct Regulation 1976. Sri Kandobo Kumar Kolita, while performing his official duties or in exercise of powers conferred on him, had acted otherwise than in his best judgment, which is violative of Regulation 3(3) of the UCO Bank's Officers Employees Regulation 1976 as amended. And Sri Kandobo Kumar Kolita has failed to take all possible steps to ensure the integrity and devotion to duty all persons for the time being under his control and his authority, which is violative of Regulation 3(4) of the UCO Bank Officers Employees Conduct Regulation 1976 as amended. The violation of the aforementioned regulation on the part of Sri Kandobo Kumar Kolita constitute misconduct punishable under UCO Bank Officers Employees Disciplinary and Appeal Regulation 1976 as amended. Then the statement of allegations, Your Lordship. The statement of allegations are there. May I read, Your Lordship? Page 56.
But you see, I'm just trying to say, I'm not completely read it. The allegations, amongst others, are to the effect that number one, you violated the policy of the manner in which loan is to be granted. This is number one. Number two, you say that in first case, in the first case,
Yes.
it says that you were required to have the proceeds insured by a RIC policy that was not done.
Very true.
See, third is that it was a trading loan which was given, whereas as per the profile of the party, it was a manufacturing unit of cloth and resin bag manufacturing.
Yes.
So it's a question of trust.
True.
So if that is not there, the normal acquisition of departmental proceeding is not done in a case of bank because it's a question of trust. So how do you succeed in dispelling that?
Your Lordship, with respect to the inquiry that was conducted, my respectful submission is there was only one witness, and this particular witness was examined, and he was the one who had. Your Lordship, I kindly peruse for a moment the inquiry report at page 98. So he exhibited all the documents, the management witness, Your Lordship, only one witness. 98, Your Lordship, the third paragraph. 98. That is the inquiry report, Your Lordship. Paragraph 3. Your Lordship.
Just wrong. Yes, 98.
Third paragraph, Your Lordship, very Lordship.
Yes.
In the course of inquiry proceeding, the PO submitted 155 sets of documents, all of which being relevant to the allegations in subject charge sheet, were accepted by the EOS management exhibits. A copy of each of these MEs are given to the CEO for information. The PO produced one management witness named Topon Chakraborty, manager of Circle Officer Guwahati UCO Bank, and presented the management case through examination of the MW as also by submission of the basis of MEs. So it's only one witness, Your Lordship, and he was the one who had exhibited all the documents. In my respectful submission, that was an error committed by the inquiry officer, Your Lordship. The Supreme Court has clearly stated that the documents has to be exhibited by the other witness also. Only one witness exhibiting all the documents, Your Lordship. That is one point, Your Lordship. I'm not on the allegations, Your Lordship. Maybe the allegation against me are true. Maybe I was not observant, Your Lordship. I was negligent, maybe, Your Lordship. But with respect, the manner in which the inquiry was conducted, Your Lordship, 158 documents were exhibited, Your Lordship, by only one witness, Your Lordship, against me. There are 158 witness documents, your lordship. There is judgment of the
No,
Supreme
no,
Court.
in my career, I have seen the largest brief I have handled. There were more than 1 lakh exhibits.
True, your lordship. Very true, your lordship. I get it. It's not. That is one
You
of.
see, you see, in a bank, what would happen? It would be the bank employee who will say that this is the manual. Manual says do things like ABC. As a loan granted, it contains 10 notes, and then in the 10 documents, these are the defect number 1, 2, 3, 4, 5, 6, 7, and 9, 10. There is a violation of the bank guidelines. This is one. You see, I think it was before your times. Did you have an occasion to participate in that LOC scam?
No, your lordship.
This is no.
No.
It was before you.
Yes, it was before me.
Okay. An incident. Some incident happened. Some deliberations were going on in this courtroom about the date on which the matter came before the bench. A week before, I was referring to one of the deliberations in that LOC scam. I was just telling them, telling the additional public prosecutors about the manner in which this trial took place. I was young entrant in the bar, and we were observing those cases because it was learning experience. So you're watching the proceedings. And about after a week, the matter came before us, the same matter. And when I look at the records, I told the APP, now I can tell you in sequence what has happened. So this was something in 93, 94, I think. Aerospace scam demo number 1. Without looking at the trial court record, I could tell them that this is a sequence in what has happened. And it was, what do you call it? My memory did not fail me. About 70% I was okay.
Yes, sir.
There, it was a single witness who had, in respect of one treasury, what do you call, chain. There is one witness, and the documents are enormous. The reason is, isn't it same principle will apply, but that's why I'm.
Yes,
repeating
yes,
that.
I understand.
You see, what happens is that in the LOC scam, what has happened was that X forged a document. He went to the Department A, got a what you call a payment order for ₹100. It was tampered to make it 1 lakh. And then with the basis of document number A, B, C, and the what do you call this challans, this money was withdrawn. The trail of money. Now you have handled PMLA.
Yes, your lordship.
So now they say that the trail of money, from A it went to B,
B.
from B it went to its bank accounts. This bank account was opened by C in the name of B, and then in this bank account, this money was of treasury was, so that challan was entered, and then from here, the amount was withdrawn by that ATM. At that time, ATM was not there,
ATM
but
was
I'm just telling you now, PML from ATM, it was D who was withdrawn. And this asset, which is a proceed of crime, was. So therefore, if this chain is to be completed,
Yes,
then maybe a witness will end up 20, 30 documents.
I
And
understand.
if he is a witness of the bank or a treasury, this is the same chain he will do. He will repeat in this LOC scam, there were front load of documents.
Rightly pointed out, your lordship. I appreciate that, your lordship. But in my case, what I'm respectfully submitting, your lordship, is that this particular, there are many other documents, your lordship. There are only single witness ought not to have exhibited the same, your lordship. That is one ground that I have taken in my petition, your lordship. And then the punishment part, your lordship, the sentence, the quantum of sentence, your lordship. I have I've been discharged from service, Your Lordship, dismissed from service. The order is at page 143.
One,
143, page number 143, Your Lordship.
we have to continue someday together because at 4:30 I have a meeting.
So,
Mr. Deori,
yes, Your Lordship.
at 4:30 I have a meeting. I have to rise.
Next week, Your Lordship.
There
Hearing
is-
day.
Try to. Both sides are represented due to positive time, the matter could not be taken up today. Based on 11/6. 11/6/2024.
Deeply advised. Thanks.
Those were formative days when I was in the courtroom hearing matters. One this case and one there was a murder case. Even after, now it will be how many years? 25, 26 years.
Yes.
I can still recollect the evidence standard. There was an evidence standard by a policeman from Scotland Yard. And I can verbatim remember the evidence led. And I have repeated this, the nature of evidence led to the Director General of Police of two states. They assured that they will also deliberate and try to adopt one or two of the procedures which were done by the man, because the subject who died was murdered was a citizen of UK. And therefore, since we are outstation death of a UK citizen, the investigators from Scotland Yard came to Assam and did the investigation.
No, I was not
His
aware.
father was there.
I was not aware.
So that was the conduct. But there is a very learning experience.
It's,
You ask.
Yes, sir.
I'm really obliged, Your Lordship.
You ask it was a very learning experience. I don't know whether you've been told those stories. No.
No, actually, it was lordship, it was also telecasted on TV also. At that particular point of time, I remember the incident, it was telecasted on TV.
No, the courtroom episode. I am not interested in the other stories.
Scotland Yard's.
Courtroom experience.
Courtroom
And
experience.
we are not concerned with others.
Yes, yes. And the
Courtroom experience, learning experience.
He was young then.
Huh?
He was too young then, Your Lordship.
Yeah, it could be too young.
Deeply obliged, Your Lordship.